Hello!
Greetings and salutations was what I meant to say. I got hijacked there. Why don't you? You're so eager to start the show. Why don't you start
I just
it?
say hello is what I say.
Yeah, no, but that
Hello?
means you now own the intro.
I don't
See if
think
you can
it's
do
true.
it.
I don't think that's true. Well, you have your notes in front of you that
I don't do that off of notes.
you usually do.
I don't. I only have the ad reads on notes.
I am suspect.
I mean, you can look at my computer if you wish. I like it's.
No thanks.
Yeah,
I don't want to know what's on there.
that's probably fair.
Hello and welcome.
Yeah, there you go. You're almost doing
I was
it.
about to say the latest episode of the Jabot podcast.
Oh yeah, no, it's not. This is not the
muscle memory.
Jabot.
No,
Though
it's
people
not.
should
Also
always
check that
check out the Jabot, the other show that Kathryn hosts. I'm Joe Patrice from Above the Law. That is Kathryn Rubino from Above the Law, and we're here to catch you up on the week of legal shenanigans out there, I guess, which is the new world of thinking like a lawyer. Though, you know, the other day, I'll give a shout out once I look up who they are here. Not that I don't know who they are, but I don't remember the exact formal thing here. But the other day, I was talking to some folks and on Twitter who had recorded a podcast that kind of followed sort of the original format of this show way back when Ellie and I did it.
For newer listeners of the podcast was what, Joe?
Yeah, they were having a conversation about like how the law would operate in fictional settings, which in the very early days of this show, Ellie and I would interview somebody and then at the end provide some entirely ridiculous scenario or ask them like, what torts might Gandalf have against somebody in Hobbit? Like we would ask these sorts of fantasy questions and have people sort out the law as it would apply to these areas. And and I saw a version of, let's see here, the Legal Theory blog had a little write-up that talked about the fictional world of Upload and how the law would operate in that. So check out the Legal Theory blog. I thought it was cool, and they reached out and were like, this kind of brings back the original.
Oh, remember what we used to do.
Yeah, and I was like, oh, good. People remember that our old school days.
More than 200 episodes ago.
Yeah. Speaking of old school, Justice Scalia was in the news this week, which is hard to do when you've not been alive for several years. Yeah. But Justice Scalia was in the news as a new note published in I believe the University of Virginia Law Review. I'm going to have to check that. Yeah, no, chronicles kind of the history of a Supreme Court case involving the University of Virginia. And in the historical research of this, the author turned up a letter. Should we say like a petulant letter?
Petulant, I think, is an accurate descriptor.
A real petulant letter from Justice Scalia to the university on the occasion of them thinking of honoring him with a award, and him complaining that I believe this school was very unfair to my children who didn't get in.
But some of his kids did get in, though, right?
Yeah. Well, I mean, he had 9, right? So
Sure.
Was it 9 or 7? I can't remember.
A bunch.
A quiverful, as one says.
Slightly different religion, but sure.
Yeah. But yeah, so several of them did get in, but 2 of them didn't. And like just the statistics, they're
not all going to be.
They're not all going to be winners. Like you Xerox copy something enough times, and a couple of them aren't going to make it. But so 2 of them don't get into a prestigious school. He, of course, sees bias here because he can't see it anywhere else, apparently, or couldn't see it anywhere else.
That is the truly remarkable part. If you look at his jurisprudence, he can't see discrimination anywhere except when it comes to his own children. Then It must have been something untoward why his kids didn't get in, but not when, historically disenfranchised people don't get in.
Right. In some ways, it kind of unintentionally strikes at the core of what's going on with anti-affirmative action thinking. It's that anything that might suggest that, it's like he even in the letter says, I didn't expect special treatment, but the issue is it's baked into the status quo assumption of normality in his mind that he would be receiving special treatment. It's not that he didn't get special treatment. It's that he always had and didn't here. Sort of situation.
But it's also that his children must be good enough, smart enough to get in, as opposed to just there's a lot of people who are applying to the University of Virginia.
Yeah.
And sometimes your people don't get in. It's not necessarily anything bad about them, but there's a lot of people they have to make a class that's balanced and, sometimes you don't
These
get
things
in.
happen. Yeah.
These things happen. But to just say, oh, well, sometimes you don't get everything you want, something must have gone wrong. There must be something untoward about it. Like that is ridiculous. And listen, this is said by people much smarter than me, that this is sort of baked into the ideas of whiteness, right? That you assume that if you don't get exactly what you want, it must be something's gone wrong with the system, as opposed to seeing all the privileges and benefits that you have received up to that point.
Yeah, no, absolutely.
And the case that the note was originally about, that it was discovered from, Scalia was in fact the deciding vote, right? That he ruled against the University of Virginia.
Yeah, no, he did not recuse himself, despite having just written this pissy letter about how he would never deal with the University of Virginia again. Not now, not ever. He backtracked on that in the future. Surprisingly, he was not truly committed to his words.
This just, besides everything else we've said about it, it also makes it very clear that we need clear recusal rules, right, when it comes to the Supreme Court, as opposed to tell us how you really feel.
Yeah, no, absolutely. The only last thing I would say on this introduction before we get into our real topics for the day is we mentioned the University of Virginia. They had a strong run in the finals of our law review contest.
Yes.
But we'll congratulate NYU, who actually did win the annual law review contest for us. Check it out.
Listen, NYU's always a strong contender in the above the law review contest, but I thought UVA would take it this year. I was really impressed by their
they were both
entry.
very good.
They were both very good, and they both featured Megan Thee Stallion's songs, as we mentioned, I think, in a previous cast. But I was very impressed by both of them.
University of Texas was also in the finals.
Right.
They had a very good Hamilton bit.
Yeah.
And I'll give an extra shout out if we didn't really write a runners-up column this year, but we have a practice of only putting in the finals people, one entry per school. Right. And Virginia's second entry would have probably made the finals had they not done the first one.
Had they gone to a different school,
So we'll give Virginia the credit of winning the Constructors' Championship there. They had two very good teams, very good entries. So let's start off by hearing from our friends at Lexicon and then get into some topics.
Here's a message just for the attorneys out there. So you passed the bar, joined a firm, or even built your own. Now are you finding out that you're doing more administration than actual law practice? Lexicon can help. Lexicon is a legal services and technology provider with over a decade of experience streamlining administrative tasks like timekeeping, HR, billing, client intake, and more, so you can focus on maximizing billable hours and increasing client satisfaction. Call 855-4LEXICON or visit lexiconservices.com/go to learn more.
All right. So we've been practicing law over Zoom for
we haven't been practicing. We've been writing, but
right. We've been given the gift of lawyers practicing over Zoom.
It hasn't been great.
It is not. In fact, we had a whole competition about this. We had a bracket competition of the most epic Zoom fail. It worked out that I'm not a cat thing won, which
was an adorable Zoom fail. There have been, I think, worse Zoom fails, but they're not as funny, perhaps.
Right. I really thought that...
I think the definition of worse is a personal one, and not everyone thinks the same.
Yeah, I thought that Jeffrey Toobin had put in a lot of manual labor to be the winner, but wasn't. But hey, that was us. Well, there was a new Zoom issue that has come up that was not in time for us to be part of this competition.
Right, because it just happened.
And interestingly, it came from the same courtroom.
Same courtroom, Judge Jeffrey Middleton from Michigan. He actually had a whole section of the bracket that was dedicated to his courtroom, I believe, in the bracket, because this is not the first time something has gone terribly off the wall in his courtroom. So I think part of the issue is that he puts his courtroom recordings on a website after they happen. So it's a minefield that we can just we can keep going back to. And now that it's happened a few times, I think that folks are looking for more problems in the courtroom. But
it still is weird. Like, I understand that maybe there are problems going on every day that we aren't seeing.
I think that has to be true.
But I mean, this guy's track record at this point, statistically, I can't imagine every court is having it nearly as badly as this guy is.
I don't know.
All right. Well, okay.
But so he was not happy. I watched the full recording of what happened in his courtroom.
Well, what happened?
A defendant logged in to the virtual courtroom with an unfortunate moniker.
Okay. So I'm sure it was just like, it was something kind of mild and like not really problematic. And what happened?
It was Buttfucker 3000.
Oh dear.
Yikes. Yikes. Yeah. I mean, and as I said, I watched the clip and the poor defendant looked horrified by everything that happened. He was like, I didn't type that in, but
I typed 2000. No. So, okay. Yeah.
No, he said that his sister had set up his account and he had no knowledge of it. And obviously, it's problematic not just for using expletives, but also because it's a slur.
Yeah.
But
certainly can be. And
certainly can be.
Often is. And the prurient interest in it is largely because it is. Yeah, go on.
Sure. Well, and also just the expletive. But yes, there's lots of problems with using that username. And it was not great. The judge was very, very angry, kicked him out of the courtroom, was like, let's see if you could figure this out, and kicked him out. He logged back in with his actual name. So that was a distinct improvement. And,
I mean, who knows what this guy's actual name was? Maybe it wasn't. But no.
Well, it was his name. So on that.
Bob Hitler. And it's like, oh, wait a minute. Yeah, go on.
The judge was much happier. And I think the fact that he was so obviously, genuinely chagrined over the entire episode helped because he pled guilty to some charge, had to pay a fine. But the judge said before ending his appearance that you better tell your sister she almost got you thrown in jail. He was about to, throw the book at the defendant and send him into jail for contempt of court. But he was obviously horrified about everything that happened.
Yeah. On the other hand, from the sister's perspective, that would have been hilarious.
Maybe.
Look, I just feel like any sister who's doing this sort of thing to their brother probably would find that hilarious.
Well, sure, but you don't know when the sister necessarily.
I didn't have a sister, but I assume they're vindictive.
But,
I don't know.
Listen, no, but the point is that she might have set up his Zoom for like a friend hangout and thought that was funny.
I would assume so. I would assume it was not for the purpose of going to court.
But
although
maybe because he seemed to have no idea about usernames or anything. He seems genuinely befuddled in the video, which maybe not. Who knows?
In a lot of ways, it's just a redux of the I'm not a cat video. A cute instance where the person didn't understand how usernames worked and filters. Yeah.
Something like that. I know, but he almost got thrown into jail for contempt because of the prank gone awry.
Yeah, well, I mean...
listen, we can kind of bring this around. Make sure if you're appearing in court or have any important meetings, make sure you know the technology that you're using.
Wow. See, and by the way, and I think now that officially means that this podcast is worth at least a CLE credit, right? In practice pointers.
Make sure you know how to use whatever, whether it's Zoom, whether it's Hangouts, whether it's what's the Microsoft one called?
Teams.
Whatever it is. I don't know that one. But fortunately, I don't have any meetings coming up on Teams.
Microsoft Teams is just kind of... They
really have the best commercials, though.
Yeah, but it's sad that an organization like Microsoft can't win this battle. You would think that they would be able to do that. I guess
they didn't know it was going to be a battle.
I guess Bill probably was concentrating on his marriage at the time.
Yikes. But the point is, I mean, we didn't know back in 2019 or even early 2020 that this was going to be the technology battle that would define probably a decade.
Yeah.
But Zoom was there. They were ready.
Yeah, and what's interesting is that I think this is true. Didn't Microsoft buy Skype?
Yes, they did.
The platform that theoretically should have won this whole moment in history and didn't.
They did buy Skype. But, it's funny. Like, I didn't even know what Zoom was until I went to some legal tech conference and somebody was referencing it in comparison to their product. And so then I was like, oh, wait, what? And so then when this all happened, I did have some familiarity with some of the tech because of this job, because of our sort of legal tech focus.
You know where I first learned of Zoom?
Where?
From this show, when our producers moved us over to Zoom from Skype and said, this works better. And I was like, I don't know what this is, but all right.
Yeah, I guess the Jabot is also recorded over Zoom. So
I mean, everything now, yeah.
Well, yeah, but again, pre-pandemic.
Yeah.
But
both the Jabot and our show and the Legal Tech News, not Legal Tech News.
You still don't know the name of it.
No, well, Legal Tech News people are on it, but the Legal Tech Week Journalist Roundtable. Yeah.
It
that I'm
sounds
on.
awkward when you say the name of the show you're on.
See, on the other
It
hand,
looks like you can actually see in your eyes that you are searching for the name. Like you're like,
it's in fairness, it's the problem with so many legal technology things going with the legal tech blank naming format. I don't know. But hey, I've created engagement among listeners who will have to, who've now, since we've talked about it so much, it's like increasing, it's like no bad PR,
but
Well, I mean,
maybe
there's a little bit of bad PR.
bit.
Like if you let your sister go into your Zoom account. Yeah. So I guess to switch gears, have you wondered how law firms have weathered previous economic downturns and come out stronger on the other side? LexisNexis Interaction has released an in-depth global research report confronting the 2020 downturn, lessons learned during previous economic crises. Download your free copy at interaction.com/likealawyer to see tips, strategies, plans, and statistics from leaders who have been through this before and how they've reached success again. So speaking of law firms then, let's talk about Ropes and Gray. They made an announcement that when they come back from the problems with the pandemic, that they are not going to be going to a full 5-day work week.
Right. They're not
let me rephrase. 5-day work week in the office.
Right. Let's be clear. People will be working at least 5 days a week.
Yeah, that's very much how that goes. I mean, lawyers have a 7-day work week now, right? So 5 days in the office versus 4 days in the office really doesn't change all that much. But it is a sign of a changing trend that we've talked about a lot on the website and here.
Mm-hmm.
Thanks for adding a lot to that conversation.
You seemed like you were on a roll. I wasn't sure you needed me here.
You're such a generous improv partner. Yeah, no, but yes, we've talked a lot about what's been going on and the ways in which commercial real estate it may well change as these firms see an opportunity to dump office space and transition to a world in which they recognize that more and more lawyers are capable of working remotely, and that they've made huge investments in the infrastructure of allowing attorneys to work remotely over the last year that they don't want to go to waste. So this may not be the last of these announcements that we see, but it is a fairly big one to see a major firm like this make this a public announcement.
Yeah, and I think that we're seeing a variety of responses to what's going to happen when we come back, but it seems unlikely that requiring 5 days a week in the office will become the norm. I think that, as you've mentioned in the past, that firms will have made this investment in the online infrastructure and that stuff is not going to go to waste. And I think that particularly as we're seeing a hot lateral market, this is also a way that firms can position themselves relative to their competition. Do you have work from home priority? Are you going to be allowed to work from home? How many days you have to go into the office? Particularly if, there's folks who are commuting, having to spend that time getting into an office as opposed to just doing the work is seen as a real benefit.
Yeah. I definitely think that we're looking at, we're on the cusp of change, and it's interesting to see, and it's going to be fun to see how it turns out. Men, like the bean counters are always going to be looking to see ways to save money, and this could be it to get rid of some space. That said, at the end of the day, you went to law school to be a lawyer, not an accountant. Take advantage of Nota, a no-cost IOLTA management tool that helps solo and small law firms track client funds down to the penny. Enjoy peace of mind with one-click reconciliation, automated transaction alerts, and real-time bank data. Visit trustnota.com/legal to learn more. Terms and conditions may apply. So, I guess the final topic of the day, real quick, is that the bar exam has...
I think you're pretty salty about it.
I am.
As most things related to the bar exam these days.
Yeah. So the bar exam has put out a new, but not bar exam, the NCBE, which is the National Conference Bar Examiners, the organization that kind of claims to be a nonprofit and makes a bunch of money writing bar exams and forcing and states do them. And it's quite the little monopolistic racket. Anyway, at the end of the day, this organization has people in it who make tests, and they are, scientists whose job it is to make good tests.
Sure.
And, that's all well and good. And those folks wrote an article that was published in a journal for the spring issue that talks about ways to write a test to minimize racial bias, which is a laudable goal and makes a lot of sense. I'm totally on board with this thing.
Mm-hmm.
Well, so I guess where I get salty on this is it feels as though you could write this article and say, look, there are a lot of problems with this world. We're not going to get into that, but here's how a test could be written to at least minimize the risk that the test itself contributes to this problem.
Mm-hmm.
Instead, what these folks decided to do, because they couldn't help themselves, is write an article that said, look, we're fine. Structural racism exists, but, that's not really our fault. The reason when our test says that minority law graduates aren't capable of being lawyers, it's because we've written the perfect test and they just aren't capable. And so you just got to deal with that. It is a astounding doubling down, frankly, and one that was wholly unnecessary. I don't think anybody would have. Look, there are a lot of criticisms of the bar exam on a lot of levels, many of which deal with the way in which minority attorneys, minority law graduates, I guess, are treated by it. At no point do you have to get into that in a story about how to minimize the fact that the test per se is contributing. Because nobody's really complaining that, question 3 is biased on this test. They're complaining that the existence of the test in the first place as a sliding scale bar on whether or not people get into the profession and therefore, build the sort of representation and diversity of representation that then can translate to long-term advances. That's the problem. A world in which we have, because of the bar exam, major law schools more or less shrugging when it comes to improving diversity and instead shunting folks into law schools that then don't necessarily prepare them but take their money anyway. And then at the end, those folks are left with huge bills and not necessarily able to pass the bar. It's a compounding problem that the bar exam's mere existence creates and encourages, and their stance on a otherwise hyper-technical article about here's how we avoid writing bad questions was turned into this apology for, not an apology, but, the way in which we talk about apology, like the more proper definition of it, this apology for why it is that they get to exist and perpetuate systemic racism. It was astounding and hilarious hilarious in kind of the bad way, and that I just read it thinking, how did they think they could write this and get away with it?
Yeah, and I mean, also because as something else you've written about a lot is that, when you look at diploma privileged jurisdictions like Wisconsin, where there is no bar exam, there isn't some crazy spike in lawyer malfeasance or crimes committed by lawyers or any of the things that the bar exam is supposed to prevent people from doing, right?
Yeah.
It's supposed to be like this gatekeeping kind of minimum competency thing, and we're seeing just fine results in jurisdictions that do not have the bar exam, and Wisconsin hasn't had the bar exam in a very long time, right?
Forever,
and everything's fine there. So if you're even part of the problem, you need a better justification when the alternative is fantastic.
Right. Well, and which the NCBE people know, as they are all Wisconsin lawyers who did not take bar exams.
I mean, the irony of that never gets old.
Yeah, it's really problematic. Anyway, so this is a continuing problem with the way in which the bar exam, the NCBE operates. It is never... The amount of resources they have are not spent on making the situation better, but on continually putting out faux scholarship or white papers that blame everybody but them for the problems that they are deeply complicit in. It's a PR operation at this point more than anything else of just putting out statements like, oh, we're sorry that this happens, but we are not really involved with it. And I mean, like Exxon puts out a more heartfelt apology on Earth Day than these people put out for what's going on under their noses. And we've seen it. The numbers keep happening and they just can't stop.
And they don't seem to see that the fact that it keeps on happening does not absolve that. Like, that makes it worse. It doesn't make it better.
Yeah. Well, we rocketed through a lot of things today relatively quickly, but that is all that we had prepared. So I guess we'll begin the process of wrapping up here. So thank you for listening to the show. You should be subscribed. You should give it reviews, stars, as well as write something that helps with the algorithm and shows engagement. You should listen to the Jabot, as we already mentioned. You should listen to the Legal Tech Journalist Roundtable if you are interested in legal technology. I'm on that too. You should listen to the other offerings of the Legal Talk Network. You should be reading Above the Law as always. Follow us on social media. I'm at Joseph Patrice. She's at Kathryn1, the numeral 1. And that, I think we're
Peace.
done.